and they found you guilty of count 2 of unlawful possession of a firearm as charged in count 2. And you elected to come to the court for punishment. Are both parties ready to proceed with this phase of the trial, state
Yes, Your Honor.
defense?
Yes.
All right, state, if you would read out the enhancements.
For count 1, before the commission of the alleged offense in cause number 2022 CR 11860, hereinafter styled the primary offense on the 25th day of April AD 1996, and cause number 94 CR 5960 in the 187th District Court in Bexar County, Texas, the defendant was convicted of the felony of aggravated robbery with a deadly weapon, the Zig gun, and before the
Pause right here. This is where things quietly get serious. When the state starts reading out enhancements, they're not just listing old cases for dramatic effect. These prior convictions are being used to legally increase how much prison time the defendant is facing right now. In Texas, enhancements can turn a long sentence into decades or even life. Question for you. Should past crimes always weigh this heavily, or should each case stand on its own?
commission of the primary offense and after the conviction in cause number 94 CR 5960 was final, the defendant committed the felony of assault family violence enhanced and was convicted on the 29th day of January 2013 in cause number D-1-DC-12-904040 in the 427th District Court in Travis County, Texas. For count 2, the state is alleging that the defendant is a repeat offender, and so before the commission of the offense alleged in cause number 2022 CR 11860, hereinafter styled the primary offense on the 25th day of April AD 1996 in cause number 94 CR 5960 in the 187th District Court in Bexar County, Texas. The defendant was convicted of the felony of aggravated robbery, deadly weapon, the Zig gun.
All right. With regards to the enhancements in count 1, both enhancements, how do you plead? True or not true?
Not true.
And with regards to the enhancements as read for count 2, how do you plead?
Not true.
All right. Are there any opening statements from either side?
No, with the state will waive opening.
Waive opening.
All right, state, you may call your first witness.
Preliminarily, the state, that Your Honor, the state would like to offer and admit all testimony and evidence that was heard in the guilt innocence phase of trial.
I believe the judge can take judicial notice of those things.
All right, and the court will take judicial notice of the prior testimony, of course, with the defense's objections as well
Yes,
from the
Your Honor,
prior testimony.
and all the exhibits as well.
Yes.
Right, then the state would also offer state's exhibit A into evidence, pending any objection from defense counsel pursuant to Rule 902.
I object on lack of proper foundation and link to defendant and hearsay.
All right, the objections as it relates to hearsay, those will be overruled. It appears to the court that state's exhibit A is a self-authenticating document. However, with regards to whether or not this is connected to this defendant, then that objection will be sustained.
And Your Honor, if the state could respond, the state would respond that that goes to weight, not necessarily admissibility. It is a self-authenticating document.
No, I'm overruling her objection as far as that this document is not what it purports to be. It is self-authenticating. But what the part of her objection that I'm sustaining is that state's exhibit A has not been tied to this defendant.
Well, yes, Your Honor, I understand that.
So foundation will have to be laid to.
This ruling matters more than it sounds. The judge just overruled the defense and admitted fingerprint evidence tying past convictions to the defendant. That single decision is what legally locks in the repeat offender status. Without this link, enhancements could fall apart. This is courtroom chess. One technical move can decide the entire punishment phase. Do you think the defense had a fair argument here, or was this always inevitable?
Somehow tie this document to this defendant.
Please, tell the court what your area of expertise is,
I'm a fingerprint examiner for the Bexar County Sheriff's Office.
and, do you have any, you possess any certification?
Yes, I have a certification in classifying fingerprints as well as identification of fingerprints.
Please explain what those entail.
So we go through a rigorous course to understand the characteristics of fingerprints as well as on-site training to understand fingerprints.
Let's talk about fingerprint specifically. What is it?
A fingerprint is a print that consists of 12 characteristics that can identify an individual.
Have you ever found two different people to have the same set of fingerprints?
No, not to my knowledge.
Can you please explain how you do a fingerprint comparison?
So when we first get the fingerprints, we do look for, like I said, the 12 ridge counts. And we will compare to see if the individual that we do have in custody is the same person that is on the fingerprint itself. And then we do our Henry classification that classifies the specific characteristics of the fingerprint.
Now, if that is your way of doing it, is that the standard way?
That's the standard.
That's the what way?
The standard.
Can you take the witness on board, Ariana?
Yes.
Okay. I may be a little confused. This exhibit B, when were those prints taken?
These were taken today.
And so when you were saying that those prints were taken by me, is that the one you were referring to?
Correct.
Okay, and so there's some other prints in the packet, right?
Correct. They're on the back of it.
Okay, but you were not saying you took those. prints,
No,
right?
I didn't.
Okay, so you don't know my client, right?
No.
So you can say that the prints match. And you can say that you took the prints of my client today, correct?
Correct.
But you weren't present when the prints were taken, the original, right?
No, ma'am.
And so you can't say, you didn't witness that, or who the person was who gave the prints.
Correct.
I would object to relevance and lack of affirmative link to my client.
All right. And so is the testimony,
I'm sorry.
was it established who these prints and States Exhibit B were taken from?
I'm sorry, Judge?
Was it established who the prints were taken from in States Exhibit B?
Yes.
You did test.
What individual? Do you want to, yes.
Ms. Valdez, you testified that you took the fingerprint stakes of the B today, correct?
Correct.
Do you see the person in the photo that you took those fingerprints from?
Yes, sir.
Could you please point to that person, identify him by an article of photo?
We'll do the gentleman in the red.
You represent the record reflect that this is identified the person that you took the fingerprints from, the six exhibit B.
All right. Defense, any objection with regards to States Exhibit A and B?
I re-urge the same objections, Your Honor. She has no knowledge of the person who gave the original prints.
All right, those objections will be overruled. States Exhibit A and B are admitted over defense counsel's objection. State, any other witnesses?
No, Your Honor, the state will rest.
Defense, any witnesses?
No, Your Honor.
Defense, do you rest?
Yes,
State, do you close?
Yes, Your Honor.
Defense, do you close?
yes.
All right. As previously stated, the court is finding the enhancements true. And the court is finding the enhancements true that were read into the record for count one, and also the enhancements true that were read into the record for count two. The court will hear argument with regards to sentencing. Mr. Nicholson, you are not eligible for probation from the court. All right.
Yes, Your Honor. The state would like the court to consider states exhibits 39 and 40, which was entered in the guilt phase of trial. That's going to be the judgment from Austin for the conviction of assault and hand.
This is the emotional core of the case. The judge rejects both extremes, neither maximum punishment nor leniency. 30 years running concurrent is the court saying, I see your past, I hear your story, but I can't ignore the danger. This moment captures the tension between justice and mercy. Final question for you. Did the judge strike the right balance, or should the sentence have gone higher or lower?
And additionally, the fingerprint card that was linked to that judgment in the guilt phase of trial. Your Honor, this defendant does have a very lengthy and violent criminal history. In 1996, he was sentenced to 20 years for aggravated robbery. That's going to be cause number ending in 60 that we entered in today. He was additionally sentenced for burglary of a habitation on that same day. That's going to be cause number ending in 59 that was entered